Welcome back to the Compassionate Capitalist Show. We are going to cover a topic that literally, I think, every startup and probably every investor needs to understand, because most people look at patents. We're going to talk about patents, but in a different level of not, what types of patents and intellectual property should protect, but really some myths and some aha moments that I had when my guest, Russ Krajek. Did I say your last name right? I meant to ask that first up. Yep. When I read his book, Investing in Patents, it was it's so enlightening that this information is, the whole thing is going to be a gold nugget for those people that are listening today, because we're going to dig into some topics that I've been in this space for 20 plus years, and this was new news to me in so many ways. So let me introduce you to Russ. He is a registered patent attorney, CEO of Blue Iron, providing patent-related financing for startups and small business, financing patent portfolios and ensuring startups can enforce their IP assets. He's an active investor in the Frontier Angels in Montana, screening for the Tech Coast Angels, and on the Public Policy Advisory Council for the Angel Capital Association. And you can, if you're wondering what type of patent you should do, look in the show notes. There'll be a link there for you to understand the difference between utility and design, so on and so forth. But in this episode, we are going to dig much deeper into the why, when, and what to patent. And because I went through this book, and as I said, it was just fascinating stuff, and it's really easy to follow. It's written in common sense language. I encourage everybody together. There will be a link in there as well, or a link to his website. So today we're going to cover the concepts of data-driven patents and prophetic patents. Was a new concept to me. You'll understand what prophetic means, why a patent should map to the business roadmap, which is the viability of what the company is building, versus the tech roadmap, which is a lot of times hypothesis and trial and error at the start. And I have such a real example of this that was just tragic in the outcome for the startup. Then we will talk about the actual role of a lawyer plays in filing and advising on a patent. This was a harsh wake-up call for me, because even having a conversation with an investor yesterday on a company that I had been helping with him syndicate, and that patent was a mess and totally hindering their ability to raise capital beyond their friends and families, and in this case, actual fools. And because, it was just real common sense once you understand it. And lastly, we'll talk about monetizing the patents as a value in the way the startup grows, but also in financing tool when the company is in a growth mode. But first, Russ, welcome to the show.
Thank you.
I always have to ask my guests to fill in the blanks of their journey. You got your law degree. Did you know you were going to do patents from the very start? And then this is typically a service provider that may dabble in angel investing, but you are a force in the angel investor community with all your roles that we've talked about. How did all that happen?
Because it didn't happen that way. It didn't happen in that sequence. I was an engineer. I was an engineer for a bunch of years. I had been through the patent process when I worked at Hewlett Packard and other companies. And then I had an invention I wanted to license, and I went to a patent attorney who was on my hockey team, and the guy cleaned me out. He gave me no advice, cleaned me out for $5,000 to do 2 really bad searches. And then I was so disappointed that I took the patent bar, because another buddy was taking it. So I took it at the same time, became a patent agent, worked for the guy who ripped me off for 3 years. And then I went to law school. So I went to law school in my mid-30s, and, and then went solo, and have, done a bunch of things, did a startup company. I did this patent finance thing, and we do insurance for patents and so on. So I came about it in the non-traditional way.
Okay. And then how did that lead you into angel investing?
Well, I was going to a lot of angel, at first when you're starting out as a patent attorney, you're trolling all the angel groups looking for clients. And so I was showing up at a lot of the events, and then I wound up having one big corporate client that sucked all my time. So I kind of quit the angel thing for a while, and then, got back into it later on. And the angel investing thing is fascinating. It's interesting. It's fun. You get to see all kinds of cool investment ideas. We're doing a version of it now where we're doing IP backed loans. So a company that may have been, and we need companies that have revenue for this. Angel investing is, that risk profile is more product market fit risk. Can I get them to sales? And once they have sales, we can take them the next route by doing debt financing instead of venture A or venture B or C or D round.
Okay. So they save their equity because they're doing they're putting value on the patent portfolio.
It's non-dilutive funding, provided that the company has revenue. And there's lenders that do that. We have a fund of our own. There's other lenders for larger deals, but yeah, companies that have 5 million of revenue, we can do 40-80 million dollar loans for them.
Wow. So we're going to come back and put a pin in that. We're going to come back and talk about that as part of the journey because everybody kind of knows in the startup world, when you get your patent, the difference between patent pending and patent awarded becomes a value, piece of that. So let's go back to this idea, because this thing of a data-driven patent versus prophetic patents.
Yeah.
I'm going to introduce that, and you're going to talk about because I thought in the book, when you talk about understanding, I think what was the example you used in the book was ice cream maker. The ice cream maker, and it's got a way to measure the elements of an ice cream maker, but then somebody comes out with something that's pre-measured and your patent isn't worth anything. And so you have to really understand your business part of it. You don't even I just read it yesterday, so I know this stuff. But let me give my example. I had this company and it was a pretty clever idea, but they had not done any market analysis. They wanted to be able to create a VR headset that you could put the face of a celebrity on the person you were looking at. It was back when there was like a crazy thing that was happening where all those memes had celebrity faces on them and stuff like that. And so you could lip sync or something, and you could be, singing with Taylor Swift or whatever. And you would, because you would see them through your thing. And also, in, potentially like intimate settings and stuff like that, right? But they had not done any kind of, but their patent was on the process of data going from a headset into a computer into this whole thing. And so they had to spend 50 grand on this process, its data process. But you could never have done what they were trying to do, because at the time, the VR headsets were like make you dizzy, and they were like these big these giant goggles. How could you ever kiss someone with these giant goggles on, right? And so it was like there wasn't a market for what they were trying to do, and so their patent was irrelevant. It was completely irrelevant. It was useless for what they ultimately was going to make, and that was because they had not made a prototype. They had not anything. They had an idea that they patented an idea. So with your own examples, whatever, but explain to our listeners how that's a prophetic patent. It's an idea, it's a hypothesis versus actually what is the business that you're going to be in.
Well, it's prophetic in the sense that it looks ahead. I'm prophesying, wouldn't it be cool if everybody was doing this thing? And wouldn't it be cool, right, if all these things existed? And to some extent, every patent has an element of that. But because I'm doing a lot of financing around patents, kind of the way I describe it today is I want to get a patent on the reason why your customer bought your product. I just want the last step in that whole chain. Why did they buy your product? If they bought your product because it had this one feature, this one button, this one thing that it did, and I can wrap a patent around that why they made that decision, I can control, I've captured your competitive advantage. And now I can protect that competitive advantage. Most entrepreneurs get in love with their grand idea, and they do a patent on the grand idea. Well, I'm going to have this two-sided marketplace. I'm going to have all these pieces all over the place, and people are going to do this and it's going to do that. And, the way I like to explain it is with this here, the iPhone. When the iPhone came out, it was the first cellular phone that did not have a green button and a red button. Every phone before it had a green button, a red button to answer the call or to end it, right? Or send it to voicemail or whatever. But their design was a touchscreen that removed those buttons. And so what's the first problem that you have to solve as you're going down the road? And that is, how do I answer a call? And so they had the slide to unlock patent. And slide to unlock is what Apple used to sue Samsung. And that slide to unlock encapsulated the entire concept of the smartphone. And it's not the grand vision of, oh, wouldn't it be cool if we had tiles and touch screens and all this kind of stuff? It's what is the thing that made it work? And you only find out when you're doing the heavy lifting. You only find that out when you're bringing the product to market. You only find that out when you're first doing the engineering and what problems do I have to solve? Oh, how do I answer a call? Oh, now I have the opportunity to build an elegant solution to it and protect that with patents. And then later on, we find out what was the customer feedback on that product. And if we're right, it's the customer experience is what you buy with the iPhone. And for all their innovation, I congratulate Apple. It's got the same exact user interface that it had during the George W. Bush administration, right? It worked, but they had sad. I'm still crying over the loss of Windows Phone because that was 100 times better than an iPhone, but
I had a Windows phone. Yeah. So
I have a whole drawer full of them.
Yeah. So like when I first got started, I remember sitting in on a seminar, whatever, in one of our technology groups here in Atlanta. And a guy was talking about how they built their patent portfolio. And I've heard it referred, another guy that I interviewed a long time ago talked about building a patent picket fence, right? And that's where you as you develop and you get other products, or in this case, the way that company did, they would they had a patent here, but then when they went over to, let's say, China or other countries, they might patent something else in that country. So they ended up having different patents they'd have like a worldwide, but then they would have different pieces and parts that would, so if somebody reverse engineered, they wouldn't be able to get past this one piece of it and they had built this strategy of this patent portfolio. And this guy that talked about the patent picket fence, his invention was the using QR codes for shipping and all of the data that went in and like that first thing. And he built a packet picket fence around there that ended up where everybody pretty much had to pay him for that, kind of, function, because he built it where it was what links to the patent was based on this image linking to a web link, not the image itself storing data. And so talk about, like, from a strategy standpoint, as people are building out their business roadmap
Yeah. So
and they validate their technology, how they can find that nuance of, like, the swipe. They didn't do everything in their phone because some of it wouldn't be worth trying to defend. They did the swipe for
no. So
that
wait a
particular
minute.
place.
There's two different ways you approach this. One, if you're a patent attorney and you get paid by the patent, you'll tell the client, hey, let's do, if we had infinite amount of money, we'd do patents on every little feature that we can. And, maybe it's kind of jumping ahead to foreshadowing your third part that you want to talk about, but it's really up to the entrepreneur to drive that selection process. And because the entrepreneur doesn't have an infinite amount of money to do 100 patents, we can only do one or maybe two or three or whatever, we have to be super selective. And so the idea of the data driven is I'd much rather wait to see what works, what works in the marketplace to why did somebody buy my product? Now, the patent attorneys are all jumping up and down. Oh, well, you have to file the patent before you disclose. And that is absolutely true in Europe, right? You have to file the patent before you show it to a customer, offer it for sale, that kind of thing. But in the US, we have a 1-year grace period. And so you can go out and start talking to people and get their feedback. And if it looks like it's a winner, get a patent on it. I am not a fan, and I absolutely detest the idea of getting provisional patent applications, especially when the inventors write them themselves. It way too many problems with it, and there is never a good business case for any startup to ever do a provisional patent application.
Well, because then it discloses to your potential competitors, right?
Well, it
Because
does
it's
when
out
it
there, it's public.
publishes. When it publishes, right? And
I'm
maybe you file the patent and you can withdraw from publication, but it's not so much that, it's that what usually happens, for bottom feeder law firms or do-it-yourselfers, they'll write up something, 1 or 2 pages, they'll send it to the patent office, they'll call it a provisional, and then all of a sudden the inventor feels like they have this protection, whatever they feel like they're protected. So they go out and they start talking to people, start chirping about their invention. And then a year later, you file, oh, you really want to get a patent application? Well, now we got to fully disclose it. And we go from a 2-page application to a 20-page application. And the protection only starts when you put you enable the claims, right? So my protection really started at the end of that year, not at the beginning. And so in that scenario, I've lost all my international rights. I've delayed getting a patent. So now I'm a year late in the queue. My investors don't get the benefit. I'm going out to raise money. Oh, well, I just have this patent application pending. Well, is it going to be good? Is it going to be bad? What's the examiner think? Well, we don't know yet, so I can't give it any credit. I can't license it. I can't enforce it. I can't get loans against it. Nothing good happens. And the whole thing about it, and think about, for angel investors or for entrepreneurs, remember that a patent application is a patent application. It's just that when we go to the patent office, we check the box provisional or we check the box non-provisional. And the only difference is a $600 filing fee. The only difference. It has to have the same information in there. And what is that telling me as the angel investor? It says that the entrepreneur went to the patent office, put the effort in, but they said, do I want to pay $600 for this and get my patent faster and get all the benefits of the patent? No, I don't see that as a benefit. So I'm going to pick provisional. And so as an angel investor, what I hear when somebody does a provisional is they did not think it was worth $600. Their value of that asset was less than $600. If it wasn't, they would have just paid the money, right? And got it faster. And so they're telling me by their actions that they don't believe in this. Then in the pitch deck, they're trying to tell me this company's worth millions. Oh yeah. It's got all, it's kind of sad that the provisionals have turned into that, but that's where they are.
Yeah. So as that segues into the next topic about lawyers and their role in this process, because one of the things, an example that you gave in the book, which I thought you might bring it up, and I think it's probably part of where, entrepreneurs feel the need to do a core dump on everything. And you have this example of a sponge, and they think, well, fibers might work, right?
Oh
And
yeah, I was
then,
talking about
and then later on, they
battery
can't
separators
or something, because later on, because that's there, it's a prior use or something. And so go talk about the clarity of what needs to be in there, the description versus the claims, and not making a mistake of revealing too much in the description versus the actual claims.
So I can go a couple different directions in that, but the as far as you mentioned kind of the relationship with the attorney. When you hire a patent attorney, you're hiring a workman to do a job, right? You paint my house, wash my car, and they go out and dutifully do what they're supposed to do. Well, tell me what your invention is. I'll write it up, and then they send it to you, and you approve it, and they send it in. But you, the entrepreneur, are ultimately responsible for how well that job was done. And if you can't tell a good patent application from a bad one, you need to find somebody who can, to help manage that attorney, the outside counsel. And this is why there's in-house counsel. I used to do a bunch of work for Microsoft. They had 40, 50 in-house patent counsel, and they had outside counsel, and I was outside. And the inside guys were responsible for living with this asset afterwards. My job was to get it through the patent office. They lived with it afterwards. They were thinking about how it's going to get licensed, how it's going to get asserted, what patent pool is going to get into. And they were designing the portfolio for how they're going to live with it in real life. And they were keeping tabs on us, the outside people, to make sure that we didn't do, certain things, patent profanity, certain words we're not allowed to use in the patent. And, make sure that has a specific structure, make sure that, it has this level of quality, and and so on. And one of the biggest problems that you have with a startup going to a patent attorney is you're asking the barber if you need a haircut. It's not the patent attorney's responsibility to tell you this is a bad idea. And this is, and I'll tell you, it's not just that the patent attorney has, mouths to feed. You would not believe how expensive jet fuel is for filling up my jet. It's unbelievable right now. But I'm just kidding. There's this liability issue that patent attorneys that I did not understand when I got into patent law. I thought, oh, this guy just wants to bill me more time. But really, the reason why patent attorneys always tell you yes is because of a liability issue.
Yeah.
If you come to me as a patent attorney and you say, oh, I want to get a patent, or should I get a patent? I'll say, absolutely yes. Early and often, right? Just like voting in Chicago. We want to get patents as fast as we can so that we don't have the, somebody can file that patent tomorrow, right? And it's a liability issue. If you come to me, that's what I have to tell you. And if I'm wrong, you sue me, right? The fiduciary responsibility for the attorney. If you're wrong, you sue me. Well, what if I'm wrong? We get a patent and the examiner says, oh, we found this perfect prior art that kills your invention. Like, well, I'm sorry, right? You sue me for $20,000, $50,000, whatever we spent on the patent. That's not that big a deal. But think about the alternative. The alternative is you come to me and you say, oh, I get this perpetual motion machine, it's going to generate electricity. I'm like, yeah, right. It'll never work. Don't get a patent. What if I'm wrong? What if I'm wrong and I told you no? And the guy down the street gets his patent, he's making billions of dollars. Will you sue me for all your lost profits in every country of the world for the next 20 years? Okay, my liability exposure for telling you no versus telling you yes is incredibly asymmetric. It's just staggering, the liability associated with giving advice as outside patent counsel. And that's why, and I didn't realize it at the time when I went to a patent attorney early on, that's why they don't give you advice. They'd love to. They wish they could. Please don't get a patent on this thing. It's awful, but they can't. It's because of the liability associated with it. And so when you as an entrepreneur are engaging a patent attorney, you got to know, who you're talking to. And, you've got to navigate that. And the way you navigate that is just educate yourself and probably have a specialist, a patent strategist who does not do the patent work. Has to be an independent third party that says, you know what, we don't need a patent on that part. We need a patent on this part.
So there's so part of the thing that I thought was really good, and we talked about it a little bit earlier, was a clarity of a patent, right? Being able that it actually it speeds up. You hear these stories of people taking years to get their patent. They got a patent pending, it takes years, and it's because the difference of a patent the patent office being able to understand what it is that they're doing, right? Well, so talk about the clarity of that plus what is actually patented, which is the claims.
So I've had patents pending for a decade or longer. Okay. So it's not immune, right? There's, been up on appeal 3 times on them. Sometimes it takes a lot of work, but the clarity part, it used to be fashionable, and it was fashionable kind of at the end of the 2000s, kind of after the tech bubble burst in 2000, the Y2K bubble. And then patent trolling started to be a thing, that it was very fashionable to write patents in legalese, right? And I'd have inventors tell, oh yeah, I couldn't even find my invention in there. So it was so badly written. Well, they didn't say badly. They were touting it as a good thing
because it was so complex.
Well, no, it's because the patent attorney didn't understand it, right? And they didn't take the time. And so a lot of patent attorneys were getting this thing where they create this huge wall of words of just stuff, right? And they couldn't figure it out. The examiner couldn't figure it out. But it's the gift that keeps on giving, because the examiner can't figure it out. So you get a rejection, you have to do a response, or better yet, even your patent examiner gives up, allows you the patent, and you go assert it. Well, it could mean anything you want. And so it was, it was perfect for the patent trolling. And patent trolling, is sometimes a derogatory thing. I mean, I'm kind of jokingly calling it, but I mean, some people are just sending out lawsuits and they'll settle for $50,000, right? And collect my money, move on to the next one. That's kind of the sleazy patent trolling narrative. that's what those patents were for. When I write a patent, I want to highlight my point of novelty. I don't want to bury the headline. I want to highlight it. I want the examiner to understand it so they can do a search, so they are comfortable that this is allowable, so that their search is so good that it won't be overturned through the PTAB and the inter parties review, so that the thing's strong enough that it'll go through licensing. I want it explained well enough and simple enough that when I push it across the table to the infringer, that they pick it up and look at it and say, oh, I get it.
Right.
And instead of, oh, I can't understand this at all, here, I'm gonna go pay my patent attorney $100,000 to figure out what it means.
Yeah.
I want it dead simple and nice and tight and focused, and those to me are the best patent applications.
Yeah, and then it's something I didn't really understand, because I thought the patent filing itself was the whole thing, but what is actually gets protected is just the claims. Is that right?
Right. The claims are where it's at.
Yeah,
and
so they could have this
that's what I get to assert.
And pictures and everything, but it's the claims.
Right, and that's where a lot of people, and the claims are, they're the single hardest thing to write in the English language, because you're trying to figure out a technology, express the technology in a way. It has to be expressed in an enforceable legal construct, and plus it has all this quirky, every line has to end in a semicolon. You have lots of these limitations. It's goofy, but it's been honed over a century or more.
Yeah.
So it works. It's just hard to do. And the truth is, when I write a patent application, I always start with the claims. And I will spend, for every 1 hour I spend describing the invention, I will have already spent 5 hours writing claims, searching claims, and rewriting them. So you focus on the claims, Does this capture my point of novelty? Who's the infringer? Who are can I detect that this thing's in, I'm worried about all kinds of things after the fact while I'm writing these claims. And then once the claims are done, the rest of it actually pretty simple, writing the specification, the description.
So address what I brought up sort of at the top of this particular section.
Yeah, you throw out a lot of topics I could.
That idea that they're throwing a bunch in, thinking that they're going to, like the fiber example, and then later on they go and file another patent, and the patent office says, oh, that's prior art
against us,
and
yeah.
so they can't actually file a patent on it, because it wasn't what was filed in the patent to begin, but it was mentioned in the description or something like that. Explain how that happens.
The patent laws changed in 1995, and before then, patents were kept secret at the patent office, and when they issued, you got 17 years, guaranteed 17-year life. In 1995, the laws changed to where you guaranteed your 17 years minimum, but every patent that's related has to expire 20 years from the earliest filing date. Okay, and so what that means is that in that 20-year period, we file the patent, the first one. There's like 3 or 4 inventions that we mention in this patent application. Then we have to do a continuation. We capture the second invention, the third invention, fourth, and so on. But as we progress down that road, all these patents have to expire 20 years from the earliest filing date. And so our window gets shorter and shorter and shorter. I have seen patents that have been pending for 17 years through endless continuations, and patents would be granted and only have 3 years left on them, right? And in the old days, this was the greatest thing ever. because we could do continuations literally for decades, and we still had 17 years of life. Today, when you put everything you know in that early filing, I'm get hemmed in on this 20-year thing. And you think at the beginning, oh, 20 years, it's like forever. Like what? It's in startup land, a decade is that's about how long it takes for a company to, especially with new technology, it takes 10 years for them to, really start clicking on what's working for them. And now they have patents that are half expired. And we only have so much time left, and we got to run the company up so that they can get a higher valuation. But if the patents only have 5 years left on them, they no longer really have value to the acquirer. And so
is the solution then to each one is completely wholly separate, so it continues on, yes, or you patent another element of your thing, because then that piece becomes the thing?
Yes, we want to reset the clock with another aspect of that early invention, right? Preferably we're doing it because the customers are buying that product, right?
Yeah, right.
We have to start out with a prophetic patent at the beginning to get us started. But once we start having that customer feedback, we know why they're buying it, and we can wrap patents around that. We want that patent to last the 20 years. And it may take us 5 years to figure that out. So we really want to focus the invention on very specific, or focus the patent on very specific inventions, or and not a whole lot more.
Yeah.
So that we could reset that clock every time we refile.
Yeah. I think that's what I was talking, this company that I mentioned at the beginning, it was like a nanotech thing. And so it was like a machine. And so they like the way this gear worked and was designed, and it was unique. And then there was this one. So they would file different patents for different pieces of the overall thing. And that's what kept their life of their patent and their portfolio going, and how that they had done it. So real quick, before we get into the valuations of patents, so one of the things that to me, and I guess it's because sometimes you're in it, so you just assume everybody knows things. But it's like when you're doing, a software product, and you are hiring developers to do it, and it needs to be work for hire, right? I mean, that's a clear kind of a thing within, so that you as the company own all the rights to that software. And you go to your patent attorney. This is the one where I talk about with the investor syndicating, discovered that the company that he had hired had equal rights on this. And he has to go through a whole negotiation thing of transferring it. And I was like, why wouldn't the attorney tell him that he shouldn't let this guy, this company, this third-party company contractor have equal rights on this patent filing? It seems like that would be something. But in the case that you described, so it really was, and I said to the investor, I said, who doesn't know that? That's like a simple thing of Googling, how do I protect my software? You know what I mean? You have, and so he would have had to tell the lawyer, file it so I have all the rights to this, and the guy I'm contracting has no rights. Otherwise,
I don't see what's the big deal. The patent, the attorneys do what they're told, right?
Yeah.
And it's not the attorney's job to run the business; it's the entrepreneur's job. And and think about it. I mean, I'm being facetious, but the attorney's going to get paid so much more to fix the problem than even at $1,000 an hour, a 5-minute conversation about, oh, well, we'll just put one line in the contract that would solve all this. He gets paid a lot more at the end. And and I'll go on another rant about the problem. Startups have, they're at a huge disadvantage in getting legal services just in general, because they're small, because they don't have a lot of billable work, because you go to some gigantic law firm and you want them to do one patent for you. I guarantee you that it's being done by the first-year associate in the windowless back room. And the reason is because the big clients come in and say, well, I want this guy, this guy, this guy, this guy working on my stuff because I trust them, because I, vetted them or whatever. But they have to train their first year associates.
Yeah.
And so when I look at patent filings from large firms, especially those that are done for startup companies, the registration numbers of those attorneys doing the work are brand new, right? This is somebody who's been practicing for a year or 2 years. And they're big name Silicon Valley law firms that are doing the work, usually on deferred billing, so they don't want to spend any money on it, and the work quality is wretchedly bad. But that same principle applies to, why didn't my attorney tell me about this? And the person who's doing contracts, employment agreements, or whatever, setting up the convertible notes and doing your subscription agreements and all that, they don't live and breathe the IP thing. That's not their ownership of intellectual property, is not their wheelhouse. They're specialized in something else. And so a lot of that stuff falls through the cracks, and we pick it up in due diligence when we're diligencing for an angel investor, for example. And you're like, how did this ever happen? It happens all the time.
All the time. Okay, so let's talk about how you value, because you have an interesting formula that you use in coming up with the value of a patent.
Yeah, I have one in the book that's a little different than what I do now.
Okay, so talk about how you do that now for companies where it's an angel stage and all the way through to the growth stage, and you're providing the financing on it.
I value patents with one word.
Okay.
Revenue. Revenue. If you show me, and revenue comes in two forms. Either you are selling product that's covered by the patent, and you've got $1 million of revenue, 10 million, whatever the number is, I can put a value on that. Or somebody else is selling the product and they're infringing. That's the only mechanism that we have to put real value on patents. And a lot of people, I happen to be a certified patent valuation analyst, for whatever that's worth. But a lot of people that do patent valuations will tell you total addressable market. Oh, wouldn't it be cool if 3 billion people were using this on their cell phone and da 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 da. And, and we got a penny from every one of them for the next 20 years. And you multiply out this really big number. That's great. It's just not your valuation yet, right? It's a potential valuation. It's a, prophetic, it's not really prophetic. It's a possible potential future valuation.
It hasn't been realized yet.
One. And we can loan against real valuation. We can loan against, hey, I'm selling $5 million a year of this product. We have patents that cover this. It protects our competitive advantage. We measure what's the competitive advantage of this company versus the status quo or their competitor, and we can measure that. Then we can put a real value on the patents. It's depressing when the inventor says, oh, I got this patent on grand thing that hasn't, and they think it's worth trillion. I literally had a guy say it, oh, my patent's worth $1 trillion. Okay. It's worth what somebody's willing to pay for it. And if somebody offered you $1 trillion, you should take the deal. But the truth is, even if we sold patents on a secondary market, infringed patents with 10 million, 20 million, $50 million of potential revenue, a decent price for that patent would be $100,000, maybe $200,000, right? And the disparity, you can sell that for $200,000. Somebody else has to invest a lot of money to recover that 50 million that might be out there, with a lot of risk, a lot of uncertainty. And so, one of the things I got to do a lot is reset an entrepreneur's expectation of what their patent's really worth today. Now we're going to invest in them, and we're going to let them grow that company from $1 million to $10 million of revenue. Great. And that patent will grow in value accordingly. So we want to invest in the company so that they can make our collateral even more valuable. I don't know if I'm dancing around your question or answering it directly.
Well, so I mean, there's really two scenarios, because I would guess that the Frontier Angels, they're you're investing in companies that have probably less than $1 million in revenue, and
Oh
they
yeah,
might have a patent, and so there's some value that says, okay, this company has a $2 million valuation, they have a patent, right? And the patent is a barrier to entry for the market that they're trying to serve, and they've got a working product. So
Yep.
there's something within there that, and maybe it's patent pending, and then when it's awarded, they go to a 4 million valuation or something. I mean, is there a formula for that, or is it just really sort of a whole bunch of factors that,
No,
come in, and there's no real science to
when
figuring
we're
out what the
doing,
value of a patent is?
when we're doing an angel investment, we're looking at the company as a whole, right? Do we like the founder? Do we like the team? Do we
Right.
like the opportunity? What do we think their chances of success are? And, and quite frankly, when you cut it all down, all we care about is, will the founder be a good steward of capital? If we gave them a pile of money, can they figure out how to make it grow? And do they have good decision making? We're more interested in, do they have good decision making processes? Do they think logically? Do they know how to, deal with the uncertainty and still move forward? That's really what the due diligence is all about. And when we look at their track record, we're looking at, have they made good decisions going forward? How have they developed and learned? But at the end of the day, we only care, will that person be a good steward of capital?
Yeah.
And
Okay.
everything else is kind of ancillary.
That makes
right?
sense. And so when you gave that example at the very beginning of a company that was like 5 million in revenue, and you might be able to loan them 48 million or something like that, that's based on actual quantitative data of the addressable market, the competition, all of that stuff, and the barrier of nobody else can do that particular product, and it's got, market impact.
Yes, exactly. The valuation, we're valuing the company, right? And the patents have to be a component of it, and an important one that we know how to reuse, resell, enforce, whatever.
Yeah. So, all right. Thank you. This has been great. BlueIronIP.com is where you go learn more from Russ. And I guess that's where they can get the book there as well, right?
I think it's on investing in patents. It's on Amazon too.
Oh, okay.
Look, if anybody sends me a nice email and sends me their mailing address, I'm happy to ship you out a book.
Yeah. Okay. There you go. There's
Save
the
yourself
offer,
$30.
folks. Yeah. I mean, and it really is. It's interesting. He's got a whole due diligence checklist in here. Very useful tool for any startup or angel investor in this space. And thank you so much for being a guest on the show, Russ. Your insights have been extremely valuable to the audience. I am certain of that. And I wish you a great day onwards and upwards.
Thank you very much. It's been a lot of fun.